All right. Well, I am live. So welcome, everyone. Thank you for joining me. My name is Lior Samfiru. I'm the employment. I am the guy that answers your questions about workplace rights. I'm the guy that tells you what you need to know if you're facing a workplace dilemma, a workplace dispute, a difficulty in the workplace, an ultimatum, a loss of a job, a new job, and you want to know what the issues, what to do about it, you've come to the right place. I do this session every week to answer questions. My name again is Lior Samfiru. I'm a partner and lawyer with Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta. And I very much enjoy doing these sessions every week because it gives me an opportunity to interact with you, to answer your questions, to tell you what you need to know about your workplace rights. So this is live. I am live right now. You're live, you're watching me, and I want you to grab your keyboard, type your question, press enter, and I'll see that question and I'll read it, I'll answer it. And you can walk away with all the information that you need to have about your workplace rights. What can you ask about? Well, you can ask about anything. I'm going to give you some examples. Vaccines. Everyone wants to know about workplace vaccines. Can your employer make you get vaccinated? What to do if they do that? Do you have to be vaccinated? Can you lose your job if you don't? Ask your question. Maybe you lost your job. You're staring at that severance letter. You want to know if it's right, if it's not, what to do, how to respond, what you're owed. Ask the question. Maybe you're being mistreated or bullied in the workplace. You want to know what to do about it. Maybe your job has changed, your compensation, your hours of work, your shifts. Do you have to accept? Do you not have to accept? How to respond? Ask the questions. Those are just some examples. There's so many more things. So take advantage of the fact that I'm here, that you're here, and let's get a conversation going. And of course, if you want to find out more about your rights, or if you want to connect with me off air, off Facebook, off YouTube, easy. You simply go to employmentlawyer.ca. Again, you see it right there, employmentlawyer.ca. That's the website. You can read a lot about your rights there, but you can also contact me through there, through email, through phone, through fax, if that's what you want to do. So employmentlawyer.ca is the place to connect with me off social media. Take advantage of that. When I shut this down in 30 minutes, I'm not going anywhere. I'm still going to be answering your questions. But I'm going to start answering questions right now. We are live. Ask your question. First question of the day through YouTube. Congratulations, Mark. You got the first question. Mark says, how does workplace reporting with vaccinations work? My employer is asking for vaccination proof on letting staff return. Very good question. And the answer here is actually straightforward, Mark. Your employer cannot demand proof of vaccination. Your employer can't ask you if you've been vaccinated or not, and can't say that only employees that have been vaccinated can come back to work. That cannot happen. Only the government can decide to implement rules like that. And governments across Canada said, we're not doing that, at least not for now. So your employer cannot do that. They don't have a right to know your personal medical information. They don't have a right to demand that. By the way, that's a breach of a statute. It's a breach of the Occupational Health and Safety Act. You don't have to provide that. So Mark, if you're still given a hard time, ultimatum, if your employer says, fine, but you're not working, I want you to contact me, all right? It's illegal for you, Mark, for everyone else. So I want you to contact me if that's what ends up happening. You know what to do, how to contact me. Just go to employmentlawyer.ca, employmentlawyer.ca. It's a very common question. I've been getting that or versions of that question for the past 3 months or so since the vaccines have really taken hold. So if you're dealing with a vaccine issue, a workplace issue at all, now's the time to ask that question. Take advantage, just like Mark did. Now, another question I've been getting very recently has to do with working from home. And really the question is, can my employer pay me less if I work from home? I've had people say, well, that the employer says to them, well, since you're working from home, you have less expenses, less commuting, less lunches, so we're going to pay you less. So people want to know, is that legal? So let me answer that. It is only legal if it's your choice to work from home. In other words, if your employer says to you, you have two options. You can come and work in the office regularly, or you can work from home. But if you work from home, we're going to pay you less. That's fine because it's your choice ultimately. You can go back to work, but if you work from home, the employer can decide how to do it. So that's legal in that situation. On the other hand, if the employer says, sorry, I've decided you have to work from home, at that point, you have no choice. And at that point, your employer cannot decide to pay you less. So it's a question of whose choice is it that you work from home? If it's your choice to work from home and your employer agrees, they can choose to pay you less. If it's the employer's decision that you have to work from home, they cannot pay you less. So I've been getting that often. Hopefully that makes sense. If it doesn't answer your question or if something is not clear, ask away. I'm here, not going anywhere. Plenty of time to ask your question. I'm going to continue answering the live question. Ask yours, everyone. It's so easy to do. Next question from Tammy. Any recommendations for someone who was dismissed and have an unsupportive union, where to go and get some advice? I had asked you last time if you help unionize people, and you said no. So here's the problem, Tammy. Unfortunately, the only one that's allowed to help a unionized employee is the union. It's not that I don't help people or I choose not to help people that are unionized. I can't. I'm not able to. So the union is the only one that's allowed to do that. And in fact, by being unionized, you've given up your rights to deal with any issues, and you've given those rights to the union. A lot of people don't realize that that's what being unionized means, but that's exactly what it means. Now, in situations where the union is completely dropping the ball, they're refusing to do what they're supposed to do, which is to represent you and advance your interest, the only thing you can do is file a complaint against the union with the labor board. That's something that honestly is very difficult to do and is almost never successful. 99% of the cases, it's not going to be successful. So it's not a really good option. The best thing you can do is work with the union, talk to your union, try to get them to do what they're supposed to. But the problem with being unionized is that you live and you die by the union. Unfortunately, neither I nor anyone else can help unionized employees. So hopefully that explains it, Tammy. Thank you for that question. Next question comes to us from John. My previous employer has dragged out paying my severance for almost 2 years. Is there anything I can do with this change my entitlements? Well, I'm hoping you're not, John, you're not dealing with your employer on your own, because if we had been dealing with your employer for you, this would have been over hopefully in a few weeks, not in 2 years. So if you haven't commenced legal action against your employer, you only have 2 years to do that. So you have to do that now. You have to do that immediately. So John, press pause on whatever you're doing with your employer. Forget about whatever you're doing. Call us, okay? There's no looking back here. There's no trying something else. I want you to contact us today, okay? I don't want to, I mean, once that 2-year limitation period expires, you're out of luck. There's nothing you can do. So contact us. Go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see my email address, my phone number, all the contact information, not just for me, but for everyone on my team. So you can use that, take advantage of it, and contact us. Don't wait. 2 years. That's crazy. That's ridiculous. Time to do something about it. Okay? Thank you. I think I'm up to date right now on the questions, but ask yours as well. We have plenty of time here. We are live. My name again is Lior Samfiru. I'm the employment lawyer, partner, founding partner at Samfiru Tumarkin LLP. I'm here every week at this time answering your questions. That's what I want to continue doing for the next 22 minutes or so. So take advantage. As I'm waiting for your next live question, ask it. Let me answer a couple of email questions that I've been getting. So this email question that I got is from Brady. He says, I'm just curious if it's correct that I'm an independent contractor. I'm a truck driver and I work for one logistics company and they own the truck. So this is a very good question with truck drivers. Many truck drivers are misclassified as independent contractors. Many truck drivers, a lot of them, and if you're a truck driver and you're watching this right now, you may identify with this, believe that they're independent contractors, but the law considers them to be an employee. Generally speaking, if you work for just one company, you're going to be considered to be an employee of that company. Doesn't matter what piece of paper you've signed, doesn't matter how you pay your taxes, doesn't matter if they withhold taxes off your pay, the law considers you to be an employee. So because of that, you have the rights of an employee, including overtime, vacation pay, and very importantly, also the right to get severance if at some point you're let go. So for Brady and for everyone else, most truck drivers are in fact employees of the companies they work for, but they're misclassified. This is true not just for truck drivers. This is extremely common. I bet you there are people watching us right now that have been misclassified, that they believe that they're independent contractors, but in fact, the law considers them to be an employee. If that's your situation, let's talk about it. Ask your question. I'm going to continue answering questions right now, so don't be bashful. Ask away. Next question through YouTube comes to us from Thomas. Is it the employer's responsibility to work with you for a reasonable accommodation for a disability? Thomas, not only is it the employer's responsibility, in fact, it's one of the most important obligations that an employer has. Our human rights laws require an employer to provide accommodation, and in fact, to do whatever possible it is to make sure that the employee is accommodated. So it starts with the doctor's note. It starts with your doctor saying, here's the accommodation that's needed. And then the employer has to work with you to make that happen if at all possible. Maybe that means modified hours, modified duties. Maybe that means changing your work location, allowing you to work from home, whatever it is that they can do to meet those limitations, to provide that accommodation. If an employer doesn't do that or doesn't even try hard enough, that's a human rights violation. That's illegal. So if you're dealing with that, Thomas, if you don't think your employer is trying hard enough or working with you to provide accommodation, let's talk about that. Oftentimes, just one letter from me gives them a bit of a kick in the pants and makes the situation better very quickly. So definitely a very important duty and obligation that an employer has. Again, employmentlawyer.ca, employmentlawyer.ca, my website. To connect with me off this device, off social media, just go to employmentlawyer.ca. Next question comes to us from Donna. Donna says that goes for tow truck drivers as well. Watch them, they're sneaky. So I think Donna's referring to being misclassified. Yes, I agree. A lot of tow truck drivers are misclassified as contractors, but they're really employee. But that can happen with teachers. That can happen with accountants. That can happen with anyone. I've seen it in any industry across all companies across the country. People being misclassified as contractors when they're really employees. So you're absolutely right, Donna. Sam, next question. Sam says, I was let go without any termination or severance pay and no document given to sign. Just said we are terminating your work employment. Well, Sam, your employer is allowed to terminate you, but of course they have to pay you severance. And depending how long you work there, that could be as much as 24 months. The first thing I want you to do now, as soon as you shut off your computer, or before you shut off your computer, is if there's nothing in writing, if it was all verbal, I'm concerned that your employer could later say, oh no, we didn't let you go, you resigned. So you want to send them an email or a text message now, confirming that on August 10th, whenever that was, you let me go, you terminated my employment. You want to do that so that later they can, once they realize how much they owe you, that they don't change the story. So you want to do that now. So that's step one. Step two, call me, contact us, let us help you get the severance that you're owed. Depending on your age, your position, and the length of your employment, you could be owed as much as 24 months pay. All right, so easy to resolve this, not a problem. And Sam, all you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You have my phone number there. You have my email address. There's a form, if you prefer, that you can fill out to contact me. So it's all there through employmentlawyer.ca, Sam. But send that text message now if you can, okay? Send it as soon as possible. All right, next question. Great questions today, everyone. I'm very happy about it. So ask yours as well. Next question from Catherine. I'm on disability. I'm a teacher. I exhausted my family medical leave of absence. I was discussing with HR whether I should resign or be terminated due to not being able to return. Then they terminated me for job abandonment. So the first thing I'd want to know, Catherine, is whether or not you're unionized. If you're unionized, you'd have to talk to the union what applies to you. If you're not unionized, you can be off on a disability as long as needed. Sometimes that could be 2 years or more. And they can't let you go for abandonment. The only time they let you go for abandonment is if you choose not to go back to work despite being able to. Essentially, that's a resignation. But that's not your case. So them letting you go, not only is that a wrongful dismissal, that's also a human rights violation. So we need to talk about that immediately. But again, only if you are not part of a union. If you are part of a union, different rules may apply, and you have to talk with the union as to whether or not that's legal, whether what happened to you is legal. If you are not part of the union, I can tell you it is not legal, and you need to call us immediately, today, okay? Just go to employmentlawyer.ca, again, employmentlawyer.ca, and let's chat about it as soon as possible. See, as soon as I said that, right here, you see the address, magic. So let's do that, Catherine, okay? Thank you. Next question, we have a follow-up from Thomas. I went to HR for a manager that was affecting my mental health disability, asked for accommodation to do the same job under another manager. They didn't help me with any accommodation and fired me. They wanted to demote me to a rotating shift position or have me resign. I asked again to work on a reasonable accommodation. They did not and fired me. Thomas, I mean, you're asking if it's legal. I really hope I don't have to answer that. I really hope that you know, having listened to the last few minutes, that it's completely illegal. I mean, there's so many laws being violated here that I need a calculator for it. So rather than us discussing this now, this is a bad situation. It's a situation, though, that can be resolved quickly. I want you to reach out to me. I want you to call me. I want you to connect with me today through employmentlawyer.ca, again, employmentlawyer.ca, and we can chat about it and get you what you're owed here. Human rights violation, an Employment Standards Act violation, occupational health and safety violation, wrongful dismissal. There's more. Sam, time to talk, or Thomas, I should say, time to talk. Next question, my friend Razor Sharp. I remember that name from previous sessions. When is an employer allowed to say a disability has frustrated your employment and can fire you? Excellent question, Razor Sharp. So there's two situations. Two things have to happen, for there to be a frustration of contract. Number one, it has to be a very lengthy absence, usually 2 years or more, okay? Number one. Number two is there has to be no prospect of being able to return to work. So it's not enough to show that the employee's already been gone for 2 years. The employer also has to show that it's not looking like the employee is going to be able to come back to work. And the employer can't decide that. They need a doctor's note. So if your doctor is still saying that there's no prospect of you coming back to work and it's been a long absence, then the employer can say, okay, well, enough is enough. That's a frustration. We have to let you go, and we're not going to even have to pay you your full severance, only a portion of it. But in most cases, when the employer says frustration, they miss that second component. They have not asked the doctor whether or not there's a possibility of coming back to work. And if they haven't asked the question, it cannot be a frustration of contract, okay? Hopefully that makes sense. Any follow-up, Razor Sharp, you know what to do. You reach out to me. Again, we are live. I'm live. You're live. I know you're watching. So, hey, ask your questions right now. Take advantage of the fact that I'm live answering questions. But I see another question, so I'm going to answer it. Catherine, who is, I guess, the teacher, has a follow-up. Oh, Catherine, you're in Tennessee. Nothing that I said applies to you then. We're strictly in Canada, so nothing that you hear, Catherine, on this session has any application to you anywhere in the United States, okay? So you can kind of forget anything that I've said here. This only applies in Canada, specifically Ontario, Quebec, and British Columbia. So sorry, Catherine, I can't help you, and nothing here applies to you. All right, for everyone else, ask questions, take advantage of that. But while I'm waiting for the next question, let me tell you about an extremely important tool that you have to have ready at the go at any time and all times, and that is pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca. You see the address on your screen right now. Again, pocketemploymentlawyer.ca. It's like having you with me at all times. It's like having your own employer with you for free on your phone with you at all times. You can calculate your severance there for free. You can find out if you've been constructively dismissed for free. You can find out if your matter is considered to be a human rights violation or a disability rights violation, again, for free. You can find out if your employer had just cause to let you go, again, free. You can do that and much more. So it's, we're using technology to provide analysis, to provide information. So check out pocketemploymentlawyer.ca and tell others about it as well. Next question from Rhea. Again, ask your questions. We still have plenty of time on this session, so please ask yours. Rhea asks, is it usual to ask the severance to be paid with no tax deductions? No. Generally speaking, severance is income, so it has to be there has to be tax deductions. In some cases, depending on the situation, once there's a legal process, we may be able to protect some of the money from taxes, but the general rule is that severance has to be taxed, okay? It's income, it's taxed. So the employer cannot simply choose not to deduct income. It's not possible. You know what they say, death and taxes, it's the way it is. So thanks for that, Rhea. Greg says, I'm moving to Canada. Great work, sir. Well, I will say this, if we're gonna compare the US and Canada when it comes to employment laws, I'm only talking about employment laws. Certainly, the laws in Canada are infinitely better for employees, okay? Not even a comparison. Laws in the United States provide very limited protection for employees. It's very different in Canada. We have very extensive and robust employment laws. So for what it's worth, something to keep in mind. And let's see, Diane Palmer. Can I get employment if I get fired for not taking the vaccine? Can you get EI? First of all, you cannot be legally fired for not getting the vaccine. That's number one. And number two, can you get EI? Yes, you can. But the real issue is that you cannot legally be fired if you refuse to get a vaccine. As the law is right now, it's illegal to let you or anyone go if you have not gotten the vaccine, okay? There's a good reasons to get the vaccine. I personally believe people should be vaccinated. Doesn't matter though, from a legal standpoint, if you choose not to, you cannot be fired. So Diane, keep that in mind. If you have been let go because of the vaccine or for any other reason, you want to reach out to me. You may be owed severance, you may be owed other damages as well. Okay, so employmentlawyer.ca, the place to go to. Diana disagrees with it. She says Canada isn't better. Diana, it's not that Canada is better. Canada is infinitely better. It's many times better than the US in terms of employment laws for employees. It's not even comparable, okay? So it's simply a fact. Next question comes from Kim. Can an employer make an employee pay for damages to a company vehicle? Generally speaking, if it's something that's done in the course of employment, then the answer is no. Unless, of course, you sign an employment agreement that specifically gives them that power. So if it's, you didn't do anything on purpose, you didn't take the vehicle outside the course of your duties, it was simply something that happened, an accident, you're bad, but it was an accident, no, your employer cannot make you pay for it. On the other hand, if you sign an employment agreement back when you started working that says, by the way, employee, if you ever get into an accident, you agree to reimburse us for the costs, that's different. Most employees have not signed something like that. So Kim, no. The answer generally would be no. Your employer can't do that. But listen, if you took the vehicle home and took it out with your friends, and that's when you got into an accident, it wasn't during the course of employment, that's different. At that point, you could be made to pay. Okay, so Kim says it was on personal time. If it's not on personal time, then the answer is yes. Your employer can make you pay because it had nothing to do with your job. So in that situation, yes, your employer can make you pay. So Mark asks, what if I never signed an employment agreement? Do I still have rights? That is an excellent and very important question. So let's be very clear here, and a lot of you are going to be surprised by this. For an employee, it's much better not to have signed an employment agreement. You're better to have started a job on a handshake or on an email or even something written on the back of a napkin. That is better than having signed an employment agreement. An employment agreement benefits the employer. Not signing an employment agreement means you have the full protection of the law available to you. If you sign an employment agreement, usually what that agreement does is it takes away some of the rights that you have and either eliminates them or gives them to the employer. For example, an employment agreement can limit your future severance. An employment agreement can give the company the right to demote you, to change your pay, to change your job. An employment agreement can say that you can't work for a competitor. It can do many other things as well. None of those things are legal. None of those things can an employer do if you did not sign an employment agreement. So, Mark, if you did not sign an employment agreement, consider yourself lucky. That's a good thing. Don't ask for one. You do not want one. On the other hand, if there's employers watching this, for the employers, yes, you absolutely want to have your employees sign employment agreements. For you, the employer, having the employment agreement in place is probably the best protection you can have. All right, so very important. Thank you for that, Mark. I'm going to continue answering some more questions, but again, employmentlawyer.ca is the website you can go to with more questions. It's the website you go to connect with me, to have a discussion on Zoom, on the phone, through email, what have you, employmentlawyer.ca. I can't help you on this session other than to tell you answers. If you actually need help, if you want my help or my team's help, let's connect off social media through employmentlawyer.ca. Christina says the vaccine can cause death, or the person caused the person to have disability. Okay, so, and I'm not sure exactly what you mean by that. And we're not talking about whether the vaccine is good or not. We're talking about whether an employer can make you get vaccinated, and the answer is no. Your employer cannot make you get vaccinated. So I'm not a doctor. I'm not advising on whether the vaccine is good or not. Honestly, I'm just a lawyer, not a doctor. But what I can tell you is an employer, as it stands right now, cannot legally enforce or make people get vaccinated, okay? So I think I'm caught up on questions. I'm gonna take another email. Maybe if you have another question you wanna kind of squeeze in, please do. Oh, just as I said that, question came in. This question through YouTube from Shah. I was terminated, but I didn't sign the termination document. The employer has mentioned a specific reason on my record of employment, and due to that, I'm having trouble finding employment. Are there any options? Yes. First of all, it's not even the record of employment. You could be owed as much as 24 months severance. So we need to talk about that. We can also get you a new record of employment. You will not be able to do anything on your own here. The good news is that's literally what we do for a living, day in and day out. So Shah, I'm going to answer a couple last questions, but I can't represent you here on YouTube or Facebook. So I want you to reach out to me through employmentlawyer.ca. There's severance issues here. Obviously, the record of employment, both of those are easy to resolve. So just contact me through employmentlawyer.ca. Christine says, can an employer force you to go back to work during the pandemic if you're not comfortable doing so? The answer, Christine, is yes. If your employer is allowed to be open, and if your employer is allowed to have employees, then yes, your employer can require you to come back to work even if you're not comfortable. The only exception is if there's a doctor's note that says for medical reasons you cannot work, fine. Otherwise, yes, your employer can absolutely require you to go back to work. And if you don't have a doctor's note and if you don't go back to work, that may be considered a resignation, okay? So let's see. From Vic, last question of the day. I'm on long-term disability for 10 years. I cannot go back to my job. Will my employer have to train me for a different job? I'm not well, but should I go to work? So if you cannot work, your employer doesn't have to train you, but you can require your employer to pay you severance. It's not going to be your full severance, but some severance. If you can go back to work, remember, your employer has to accommodate you. You're still an employee. You've been considered an employee for the last 10 years. If you cannot go back to work, you can get some compensation from your employer. If you can go back to work with accommodation, you can certainly go and try and even see if that works. Your employer does not have to retrain you necessarily, but if there's a job that you're able to do with your limitations, they have to try to work with you and make that happen, okay? That's all the time that I had today, guys. As always, terrific questions, terrific scenarios that you're dealing with. Hopefully I've answered all the questions, but if I have not, or if you have follow-up questions, not a problem. I'm not going anywhere. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. We can connect there. You can ask more questions. We can have a private discussion. I can actually help you. So don't forget about that. And of course, I'll be back next week. Don't wait till then, but I will be back next week. Until then, enjoy your week, enjoy your summer, and we'll talk to you very, very soon. Guys, thank you. Bye-bye.